Steve. Thank you for the great introduction and the land acknowledgement. It's nice to hear a correct land acknowledgement. They're not always correct these days. So, yeah, I'm actually, that must be an older resume I gave you, but I'm up to 30 settled claims now and well over $500 million to my clients. So, Mississaugas of the Credit was one of the first clients I got when I started working in First Nation claims, which was I started working with Mississaugas of the Credit when they were still Mississaugas of the New Credit back in 1996. Helped them settle their 200-acre claim, and then we went on to negotiate the Toronto purchase claim, which was we settled for $145 million in 2010, I believe, and very pleased to announce that they have the vast majority of they still have well over $100 million in a trust fund that they use to fund activities for their members every year. It's invested wisely and they get a great return, and the money keeps going back into the community to take care of the members, and they have a lovely new community center there that was funded from that project. So it's not only nice to settle these claims, but nice to see the money spent wisely. So I'm going to try to bring up my PowerPoint presentation. And as I said earlier, I'm a techno peasant, so hopefully it will work. And there we go. From beginning. All right, so hopefully everybody can see that.
Yeah.
I managed to get today's date correct, and even got Oakville Historical Society there. So thank you very much for having me tonight. This is a real pleasure. So you've heard most of this, but I am a lawyer. I only work for First Nations. All of my clients are First Nations. Most of them in Ontario, but I represent First Nations all across Canada from coast to coast. Not in the Northwest Territories, but elsewhere. And hard to believe, but 25 years with Mississaugas of the Credit now that I've been working with them. So a real pleasure, a wonderful group of people, and I always like to advance their cause when I can. So the Mississaugas of the Credit First Nation, and I'll use the abbreviation MCFN, are the descendants of what were known as the River Credit Mississaugas. It's interesting because they are not named after the Credit River. The Credit River is named after them. The Mississaugas, when they first were in this part of the world, dealt with the French fur traders, and they would trade at the posts. There was a French post at the mouth of the Credit River, and the French traders found that the Mississaugas were trustworthy Indians and that they were credit worthy. So they could advance them trade goods, muskets, traps, and food and provisions. And they would go off to their trap lines in the winter and come back in the spring and sell their furs and repay their debts. Hence so they really should be called the good credit Indians or the credit worthy Indians, but that's where the Mississaugas of the Credit name comes from, and that's why it's called the Credit River. So by the conquest by the British of the French in 1759, from the first treaty taken with the Mississaugas in 1764 at Niagara, through the land surrenders of the 19th century, the British Crown recognized the Mississaugas as the only Indians with title to what is now most of the GTA, or the Greater Toronto Area. You will hear me use the word Indian a fair bit tonight. It's a term that goes in and out of favor. I'm a lawyer. I tend to use the word Indian simply because if somebody says to me that they're a status Indian, I know what that means. They're an Indian under the Indian Act of Canada. usually belong to a First Nation, a recognized First Nation, or what used to be called Indian bands under the Indian Act. Several words have come in and out. Aboriginal was used for a while. A number of my friends complained that it made them sound like they were Aborigines from Australia, so they didn't like that. And the term that's most current now is Indigenous. So people that identify as Indigenous, but if someone tells me they're Indigenous, I don't know whether they're First Nation, Métis, Inuit. I don't know whether they're a member of a First Nation or not. So that's why we tend to use the word Indian. And also it is the historic term that's used. So all of our records and history makes reference to Indians. And the majority of Indigenous people that I work with, especially ones that reside on reserves, still refer to themselves as Indians. I found that the urbanized Indigenous people prefer Indigenous or some other term, but the people that are still living on the reserves in Canada, by and large, prefer the term Indian. So, there you go. So we know that based on descriptions from the Reverend Peter Jones, there's a lovely, you should get Donald Smith to speak to you. I'm sure he has already, but he did a lovely book called Sacred Feathers about the Reverend Peter Jones, who was a Mississauga chief and educated. He could read and write and was a Methodist minister. And we got a lot. It's really nice because for this First Nation, not all of their information comes from the British. Quite a bit of it comes from Reverend Peter Jones and people after him from the First Nation, because they could write and did write. So we have lots of records from the Mississaugas themselves. But he's a River Credit member and chief from 1848 through to 1855. And there's a historic document called the Paper Talk, sent to the Governor General by Chiefs Joseph Sawyer and John Jones in 1844, where they set out their territory. And what they said was that their lands extended from the Rouge River Valley in the east, up the Rouge to basically the Moraine, across the headwaters to the headwaters of the Thames River, down to Long Point on Lake Erie, back along the shores of Lake Erie or through the lake, through the Niagara River, and then along Lake Ontario to the Rouge River Valley again, the point of beginning. So as a picture or a map is worth 1,000 words, that's their territory. And I don't know, I presume you can see my cursor, but along Erie, and then so up Rouge River, across the Moraine, up to the headwaters of the Thames, down and around and back. And you can see that the borders are squiggly. There's a good legal term, squiggly, because the First Nations generally divided their territory using watersheds. So that's how they would know whether they were in their territory and somebody else's territory, based on watersheds. So that's why the lines are all squiggly, and you'll see later on that the British didn't get squiggly, so they drew everything in straight lines. But so there you go. So that's the outline of their territory. And the question is, how did it become their territory? Unlike a lot of First Nations, they cannot say that they've been here since time immemorial, because they were not. So the ancestors of the Mississaugas of the Credit came to southern Ontario and took over by means of a military conquest. And in that sense, they're much like us. We defeated the French and took over what is now Canada, and the Mississaugas defeated the Iroquois, basically. But what happened was that in the 1600s, by about 1649, we think, pretty well documented, the Iroquois had by and large trapped out their beaver hunting grounds in upstate New York, which was their traditional territory. And they wanted to expand, get more furs, get more trade going. So they invaded southern Ontario, which was occupied at the time by the Huron and their allies, the Neutrals, Tobaccos, and many other First Nations that lived here. If anybody's read Joseph Boyden's book, The Orenda, that describes the Iroquois invasion of southern Ontario. That's what that's all about. So the Iroquois invaded southern Ontario, pushed the Huron and their allies out, and then continued on northward up past Parry Sound, up into north shore of Lake Huron, actually, from raids and whatnot. And then eventually the Ojibwe, or as they would call themselves, the Anishinaabe, formed a coalition and decided to push back. They'd had enough of the Iroquois incursion into their territory, enough of their raids, and they fought back. They formed what's known as the Three Fires Confederacy or Council, and started what is now known as the Beaver Wars. And the Mississaugas and their allies, which are basically the Potawatomi and the Odawas, they drove the Iroquois back into their homelands south of Lake Ontario and Lake Erie. So they defeated them militarily, drove them out, and occupied the land. So at the conclusion of the conflict, many Mississaugas settled at the eastern end of Lake Ontario, and you will find 4 Mississauga nations there now: Alderville, Scugog, Hiawatha, and Curve Lake. Those are sister nations to Mississaugas of the Credit. The remaining Mississaugas settled at the western end of the lake, with their primary location at the mouth of the Credit River, which is now Mississaugas of the Credit First Nation. And other groups occupied the rest of southern Ontario. So you have the Chippewas, Georgian Island, Christian Island to the north. Got Chippewas of the Thames, Walpole Island First Nation, Caldwell, down to the southwest of us. So this was prior to the conquest of New France by the British. So Mississaugas took possession of southern Ontario in about 1700, dealt with the French for a while. But then in 1759, we know what happened then. Britain took over New France. And from 1781 to 1820, the Mississaugas entered into 8 different surrender treaties with the British Crown that covered their territory, that as described by the Reverend Peter Jones. So again, a good map is worth lots of words. So here are the treaties listed in chronological order. So the first treaty was Treaty of Niagara in 1781. The British had originally purchased it from the Senecas, who were part of the Iroquois, only to find out that it wasn't Seneca to sell, and it was actually Mississauga land. So they repurchased it from Mississaugas in 1781. And then they take this huge surrender, all this purple land, and yes, it does go past the edge of their territory. And that has to do with the British not really understanding the geography very well, and they drew the boundaries of the treaty extending down into Chippewa territory. That's subsequently been dealt with and straightened out. But so this was called the Between the Lakes Purchase, and that was done in 1792. As we'll find out a little bit later, it was done primarily to relocate Joseph Brant and his followers and the Empire Loyalists that around the American Revolution, and the British were realizing that they were going to have to get land in Upper Canada to resettle the people from the United States that didn't want to live there anymore, wanted to be under the British Crown. So you get the Brant Tract in 1797, which is this tiny little thing here. That was another piece of land taken for Joseph Brant. The Toronto Purchase in 1805, that's a settled claim. And the Head of the Lake Purchase, which was this one here, And then the Adjunts Purchase done in 1818. And then the subject of our talk tonight, Treaty 22 and Treaty 23, which if you look at the insert here, whoops, what have I done? I've jumped ahead to the Between the Lakes Purchase. So we have another map of what we're talking about, so I won't try to back up. So the Between the Lakes Purchase, as I said, in 1776, Joseph Brant supported Mohawk, a part of the Iroquois nation. He supported the British in the American Revolution. He successfully defended his territory upstate New York, and then watched the British deal it away in the Treaty of Paris in 1783. So the British gave control of all of Joseph Brant's territory to the United States. So Joseph Brant wanted to relocate to friendlier location. He wanted to come to Upper Canada, and British purchased land from the Mississaugas to accomplish that purpose. And land surrenders were taken from the Mississaugas to secure territory for Joseph Brant at Six Nations, the Haldeman deed, which we'll talk about, and also the Tyandinaga Reserve down near the Bay of Quinte. Was similarly, land was taken from the eastern Mississaugas to relocate the Six Nation members there. So the Haldeman deed was granted to Joseph Brant in 1784. That was a strip of land 6 miles on either side of the Grand River from mouth to source. And that was on land surrendered by the Mississaugas in 1783 to the British Crown for the express purpose of relocating Joseph Brant. The Mississaugas knew what they were doing. The British Crown came to them and said, we want to relocate Joseph Brant. We want to move him here. And the Mississaugas said, fine, we will sell you land for you to do that. The River Credit Chief Wabaneb, sorry, my Ojibwe is not good, stated at the time that the Grand River lands had to be given to the Six Nations to mark the relationship the two nations had with each other. Although they from time to time, they were mortal enemies and fought huge wars, they also managed to live together and became friends from time to time. So that grant was confirmed, reduced in size somewhat in 1793. This is a sort of an aside, but it's a nice aside. We also have a water claim that we filed with Canada and Ontario, and that was on the basis that the Mississaugas didn't surrender their water to the Crown. And this is not based simply on the fact that the treaties are silent with respect to water. The Mississaugas actually asked the British. They said, and it was confirmed in 1805 at the time of the Toronto Purchase, where one of the chiefs said to the British, you've always told us that you don't want our water, you only want our land. And the British confirmed to the Mississaugas that yes, they could keep their water. They were really only interested in the land. And that was so they could relocate the settlers. And the water was very important to the Mississaugas. They ate a lot of fish. In those days, the salmon still ran freely in all these rivers. And as we'll see, these three last reserves that we're going to be talking about tonight were all rivers. And they all were kept because they were good salmon fisheries, and they also had fertile lands beside that they could grow crops on. So they never surrendered their water, and that means that they have a claim to the water. That's a separate claim. We filed that one in court. It's in abeyance right now. We're going to deal with it later because, in part, because the Saugeen Ojibwe Nation is proceeding with a court case right now dealing with Aboriginal title to water in their territory up on Lake Huron. And we want to see what the courts do with that one before we deal with this one. So Treaties 22 and 23, that's what we're talking about. And these two treaties took place in 1820. And it resulted in the River Credit ceding the last of their lands to the Crown at 12 Mile Creek, which is Bronte, 16 Mile Creek, Oakville, and the Credit River Port Credit. So again, map's worth 1,000 words. Here we go. So there's Bronte, part of Treaty 2022. Oakville, smack dab in the middle of Treaty 22. And this piece of yellow and that piece of yellow are Treaty 22. Treaty 23 is this sort of orangey pinky bit in the middle of the Credit River lands. That was taken by the British to facilitate the construction of the Dundas Highway. And it was a different natured treaty from the Treaty 22. It was a straight out purchase to facilitate the building of the highway. But you can see how each one of these lands that they had reserved for themselves was a river, because rivers were important to them. There it is overlaid on a township map. It gets a little fuzzy, and unless your eyesight's better than mine, it's hard to read. But basically, we know what we're dealing with: Bronte, Oakville, and Credit. So I've been working with Mississaugas of the Credit for a long time, and these two treaties just totally mystified me. I could not understand it, because this was the last land that they owned on this planet. They had no other place to go. They had no other place to live. These were very important rivers that they needed to feed themselves and their families. Why on earth would they surrender these last little bits of their land to the crown and leave themselves with no place to live? Well, and the answer is simple. They didn't. What their ancestors thought they were doing, and because the crown told them that this is what they were doing, was placing the lands into the hands of His Majesty to hold in trust for them so they could live there unmolested forever. So we've got some nice quotes here. And Chief Joseph Sawyer was one of the chiefs at the time of the Treaty 22 in 1820. And he spoke several years after the treaty, but it's about 5 years after the treaty, I think. So it's, when he says several years ago, he's not talking about something that was 100 years ago. It's something that happened in his lifetime, in his recent memory. So this is a quote from Chief Joseph Sawyer. And he said, "Several years ago, we owned the land on the 12-mile creek, the 16, and the Credit. On these, we had good hunting and fishing, and we did not mean to sell the land, but to keep it for our children forever. Our great father, Colonel Claus, who was the British representative at Treaty 22, went to us and said, 'The white people are getting thick around you, and we are afraid that they or the Yankees will cheat you out of your land.'" And he went on to say that Colonel Claus had said, he was the deputy superintendent of Indian Affairs. He said, "You had better put it into the hands of your very great father, the king, to keep for you till you want to settle, and he will appropriate it for your good." Still a quote from Chief Sawyer. He says, "Some of these words were thought good, but we did not like to give up all our lands, as some were afraid that our great father would keep our land. But our great father had always had great confidence in him, so we said, yes, keep our lands for us." And of course, what happened instead was the crown took the lands and sold them all to settlers between 1820 and 1847. There's a long story to that, and why and how it happened. And to tie it up with Oakville, it was in 1827, Colonel William Chisholm purchased land at the mouth of 16-Mile Creek and started building what is now Oakville. So only 7 years after the treaty, the lands at Bronte, I believe, had already been sold off. Oakville was being sold off by 1827, only 7 years after the treaty. And why on earth this happened? What happened? We have to remember a couple of things. In 1820, the Mississaugas were still not sedentary. They were still living off the chase. They pursued game, and they traveled with the seasons. They didn't have houses, they didn't have homes, they were not settled anywhere. So these were places that these three river mouths that they wanted to keep, where they could camp, spend the winter or the summers and fish. And what they thought they were doing was placing this land into the hands of the crown, and that the crown would keep these lands and that they would take care of them there. This was an unusual treaty. Treaty 22 was actually the first surrender in trust to Her Majesty to happen in the history of Canada. It was the first real establishment of what we believe was an Indian reserve, or what came to be an Indian reserve under the Indian Act when it was finally created. And when Reverend Peter Jones took over, and there's a lot of people think that at the time the British thought that the Mississaugas would simply die out. They were having a lot of trouble. They had problems with alcohol and disease, and I think the British just thought they would die off and they'd go away and they wouldn't have to worry about them. But Reverend Peter Jones took over the leadership of the First Nation, and he established the first permanent residence of the Mississaugas at what is now the Mississauga Golf and Country Club. I don't know what it is about Indians and golf courses. When you think of Oka, and there seem to be many disputes that involve First Nations and golf courses. But they built a really nice village, an excellent village on the banks of the Credit River, cleared a bunch of land. They had excellent houses. They had barns. They were haying. They had animals. It was a model community. People used to come from miles around to see it and see what, they were amazed what the First Nations were doing, and how they were very successful farmers. But they kept asking around for the deeds to their land, because they realized that they didn't own the land, that they'd surrendered the land to, or given the land to His Majesty. And they'd seen His Majesty sell off the majority of Treaty 22 lands, and they were very worried that the Crown would sell the land out from underneath their feet, including the land that they had made their improvements on. And Reverend Peter Jones actually traveled all the way to England to meet with Queen Victoria, and he left with what he thought was an assurance from her that they were secure in their village on the River Credit, but it was not to be. A gentleman, there's 2 streets just down from where I live in Oakville. I should point out to you that I live on Treaty 22, so I'm very interested in this. There's a street, Bond Street and Head Street, and it was Sir Bond Head who was the head of the Upper Canada at this time, and he didn't think much of Indians, and he wanted them to remove from all of the civilized parts of Ontario, and he wanted the Mississaugas out of there. He wanted the land at the River Credit for white settlers, and he flat out refused to give them title to their village. And they really had no choice but to relocate. Any place else to relocate, they did not. The Mississaugas had surrendered millions and millions of acres of land to the Crown. The Crown did not offer them any land in return. They originally thought that they might go up to the Owen Sound area and settle up there, and they actually went up and checked it out. And if you know Owen Sound, it's not the best farmland in the world, and these guys were farmers. And they said, nope, that's not going to work. And in 1847, they were sort of at their wits' end, and their ancient enemies, the nations, said to them, well, we have land here at the Grand River that you gave to the Crown to give to us. We're happy to give a portion of it back to you. And they did, and they gave them a piece of land near Hagersville on the southwestern corner of the Six Nations Reserve, and that became the new credit reserve. When they relocated from Port Credit to Hagersville, they called the area the New Credit. And they settled again upon what was part originally of the Between the Lakes Treaty and the Haldeman deed that had been granted to Joseph Brant. So looking at all of this and doing the research on all of this, we've prepared land claims and given them to Canada and to the province of Ontario. We've not gone to court yet. We're trying to do this through their claims process as an out-of-court resolution. And what we're saying basically is that when the Mississaugas placed these lands into the hands of the Crown, they did so in trust, and they believed and were told that the lands would be held for them and used for their benefit and that they'd be able to live there. But they never surrendered the land to the Crown for sale. They didn't understand that the Crown was going to sell these lands. They thought the Crown was going to hold these lands for them. And when there's a piece of land that's owned by Her Majesty and set aside for the use and benefit of a First Nation, that is the textbook definition of an Indian reserve. So we believe that the parcels at Bronte, Oakville, and Port Credit are still reserve lands today, that Mississaugas have never surrendered them for sale, and that they're owed financial compensation for all of this. And regardless, and we'll get into this, another lawyer that you might have heard of, a gentleman by the name of Sir John A. Mcdonald, had a look at Treaty 22, because in 1855, the chief clerk of the Crown Lands Department declared that or remarked on the peculiar nature of the deed of surrender for Treaty 22 may involve a legal question as to the construction it will bear. Fancy words for what the heck is this? And in 1857, John A. Mcdonald wrote a legal opinion that we have today in our hands. He was the Attorney General for Upper Canada at the time. He opined that Treaty 22 contained an express trust stipulating that all profits garnered from the sale of the lands and all land sale proceeds must be spent on behalf of the Credit River Indians. And of course, this did not happen. So either way, I mean, we have the oral understanding of the treaty from the Mississauga saying, we gave this land to Her Majesty to save for us. We didn't expect it to be sold. But even the British, when they wrote down in this treaty, it says that these lands are surrendered in trust and they must be used for the benefit of the Mississauga Indians. So I think either way, we have a valid claim here because the lands were sold, the monies were not paid to the Mississaugas, and either way, it's either these are still reserve lands and it needs to be addressed, or if the lands were sold, then the money has to be dealt with as to what happened to it all. So on May 28, 2018, the claim for Treaty 22 and for Treaty 23 was submitted to the governments of Canada and Ontario. We're in negotiations with both governments now on how to proceed. I'd like to point out that Canada in particular, and Ontario as well, are being very cooperative. We've done some joint research with them. We're looking into the facts, trying to get the history straight. And Canada is now preparing a legal opinion of their own on the submission that we made, and we're hoping to hear the not too distant future from Canada about how they're going to deal with this claim. One thing that we need to point out, I'm one of those people that lives on this land. The Mississaugas of the Credit are not seeking title to any lands currently owned by businesses or residents of Oakville. We're not trying to displace the people that live here. We're not trying to displace the businesses and the owners. We understand that two wrongs don't make a right, and essentially this will be dealt with by way of financial compensation and perhaps the land elsewhere. There is some Crown land here, some municipal lands that are owned that we may be able to secure But primarily, I think this will be a money claim. And miigwech, which means thank you. That's my presentation. And I'll see if I can stop my share now, and hopefully Steve can open her up to some questions.
Right. Let me see if I can. Everybody can unmute now. If I can find a button, I will. Found it before. I don't know why I can't find it now. Oh, there you go. So I've invited everybody to unmute.
Yeah, I could start by answering some of the questions that Stan sent in. And he sent in 7. So they're in the chat. And I can go through them one by one if you like, Steve. Would that be a good way to proceed?
Sure, that would be awesome. I don't see 7 questions from Stan, but I guess.
No, in the chat?
Yeah, you see something I don't, I guess, but sure, go ahead.
Okay, well, the first question he was or wanted me to comment on is the English interpreters gave false translations to your Aboriginal leaders. We don't have a lot of evidence of the British Crown deliberately misleading Aboriginals. I mean, sometimes they did, but not really. It was more a case of two cultures that really didn't understand each other and didn't see the world in the same way. So the British came to the Mississaugas and said, look, we've got all these people down in the United States. They're going to relocate up here. It's going to be a good thing for you. They'll have some farms. You can sell goods to them. You'll be able to hunt and trap on the riverlands, and everything's going to be fine. And the Ojibwe didn't have a concept of land ownership the way we have a concept of land ownership. So to them, you didn't own land, you didn't buy and sell it. They used it, you took care of it, and we really see these treaties as more of a sharing, or that they were paid. The Mississaugas understood themselves to have been paid so that the British could share the land with settlers. They would, if you'd shown the chiefs back in the 1800s what GTA looks like today, they'd be appalled. It was like, if they saw this tsunami of white people coming, I don't think they ever would have signed these treaties. That's not what they understood. Number 2 was that the Aboriginal leaders do not understand the documents and treaties they sign. That is, I think, in many ways true. They didn't always understand them. Sometimes they got some of it right. Sometimes they didn't get it right. I think that the Mississaugas had a pretty good understanding of Treaty 22, and they were giving the land to the Crown. The Crown was going to keep it forever, and that they'd still be living here today. And that's basically what the British told them. So it's not so much that they didn't understand the treaties. The treaties were not always implemented the way they would have thought. Question number 3 was Aboriginal leaders were forced to sign such documents. They weren't forced to sign them so much as they were induced to sign them. And the Ojibwe had a relationship with the British Crown where in some ways they were dependent on them. The British gave them presents every year, muskets, clothes, and whenever they had a gathering, the British would put on a feast for them. Whenever they had a treaty, they would have a feast. And if you looked at the provisions of supplies for the treaty feasts, they always invariably involved many, many, many barrels of rum. So the British were plying them with liquor. I don't know if half the time whether they understood what they'd agreed to the next day. So, the rum was used as a trade good. Aboriginal leaders do not actually, the 4th question is Aboriginal leaders do not actually sign some significant documents. That is, relatively accurate with respect to the Toronto Purchase, which is another long and complicated story that we could go into. Fascinating story. But the original treaty was taken in 1787 or 1788. And when the British Crown asked for the copies of the treaty later on, they found that the document wasn't signed, or that where the signatures were, they had been wafered onto the document after the fact. And so they redid the Toronto Purchase in 1805. And that time the Mississaugas did sign it. Question number 5. Canadian Constitution excludes ownership of land due to unsettled land claims. No, I wouldn't agree with that one. There's lots of unsettled land claims, but I don't think that's why the Constitution doesn't refer to land ownership as a basic right. That's another story. There was question number 6, was there's never a valid treaty for the area that Toronto now covers. I just gave a brief history of that. The original treaty for Toronto was took place in 1787 in the Bay of Quinte, followed up in Toronto in 1788. That's the one where they didn't have the proper document. It was corrected by the Toronto Purchase of 1805. So there is now a valid treaty covering that land. We filed a claim with Canada and have settled that claim. In part because the Crown took a lot more land than what they'd agreed to in the treaty. So they hadn't paid them properly for the land in 1805, and that was the basis of the settlement that we entered into. Number 7 is the Mississaugas of the Credit First Nation are content with the way their treaties were handled and their lives now. No, I wouldn't say that. We're working on lots of claims and putting forth arguments for them. They're doing very well. I think that the British from 1820 would be very surprised to see how well the Mississaugas are thriving, and how their children are doing well and going to university. And one of their members, and one of the reasons why I'm in First Nations law, is that Harry Laforme was one of the first First Nation lawyers in Canada, and he was practicing in Toronto. I knew Harry very well, and he got me to work for him at the Indian Commission of Ontario in 1989. That's how I started working with First Nations. But Harry had an illustrious career and went on to be appointed as a member of the Court of Appeal for Ontario. We think that's the highest ranking Indigenous position that's been occupied in the Commonwealth for a First Nations person. Yeah, the Mississaugas are doing very well. They're in self-government talks right now with Canada, establishing their own laws and working on getting themselves together. But they're not too pleased with the treaties. We're working on all of those, but they're making the best of what they got. So those are my answers to Stan Smirlik's questions.
Thank you very much.
And open it up for anybody else that's got anything to ask.
It's good to know that you guys, that the Mississaugas don't want to take my house. So we haven't
or
been
mine.
yeah, exactly. So these kind of things are always curious to me, because a lot of these things happened back in the early, mid, late 1800s, and yet compensation is dealt with in today's dollars and today's time. How do you reconcile those kinds of things? I mean, I understand, you can't go back that far, but how do you find the middle ground, which is what I assume most of the settlements become?
Well, actually, we do go back that far. And on this type of claim, we will usually, and have already started the process of identifying all the lands that were in Treaty 22, looking at the trust records. And basically, what this is that when you surrender land and trust to Her Majesty, that creates what's known in law as a fiduciary duty. So the Crown had a fiduciary duty towards the River Credit Indians to make sure that they got the benefit of all their lands. And even Sir John A. Mcdonald agreed with that. He said, you guys know what you've done. You know, you have to make sure the Indians get all the money from this. So we will document all of that land sales, look at what what was sold, what money, if any, got into their trust account in Ottawa. And then we will start a process of negotiation on how to bring those dollars forward to today. That's often a long and difficult negotiation. But so you identify what was owed back in the day, and then try to find a way to bring it forward to today's dollar. If you simply use compound interest, it would soon get into the billions and would be overwhelming. So, you know, these claims are old, but because they're based on a fiduciary duty by the Crown to the First Nations, then the Crown has an obligation to make good on their fiduciary duty to the First Nations.
So if I understand what you're saying, Kim, you're saying that based on an investigation, if you think the value of a piece of land was $10,000 or something in 1820, that's the settlement, but now you've got to convert it somehow into today's values in dollars and stuff. Is that correct?
That's correct. Yeah, that's exactly what we do. Complicated negotiation, and often takes years, but we arrive at a figure that both parties can live with and we think would be supported by the courts if we went there.
So how were the lands compensated that far back? Like, I mean, as a kid, you hear stories of like beads and blankets and like stupid stuff like that. I assume it's a little more sophisticated than that for most of them. And I'm like you said, some of these are legitimate and they paid them something, some form of, like, either gave them crown land, gave them land, or gave them money or something. Like, how did they figure out the value back then?
Essentially, the British would come up with an amount and say to the First Nation that this is what we want to pay you for your land. The earlier treaties were done by way of trade goods. So they would say to the First Nations, we're going to give you, 5,000 pounds of trade goods, not weight, but English pounds, money. 5,000 pounds worth of trade goods. So they would have given them rifles and copper pots and knives and hats and clothing and rum that would have totaled up to the amount. By the time of the later treaties, Treaty 23, for example, for the Dundas Bridge, was a cash payment of a couple thousand pounds, which a lot of British civil servants basically at the time said that's an appallingly low figure for this piece of land, but they were paid cash for that land. And this is one of the reasons why they always said, and still say, that they never sold their lands at River Credit. They never sold their lands at Bronte. They never sold their lands here in Oakville because they didn't get paid for them. Treaty 22, there was no exchange of monies. They put the lands into the Crown's hands in trust, and they expected the Crown to hold that land for them. Instead, the Crown sold the land. So they've always said, we should, we never sold that land to the Crown because we never got paid for it. It's a very complicated process that we'll have to go through, looking at all the land sales and what happened to the monies that were sold from these various parcels of land. It should have gone towards the River Credit Indians. We're quite certain that most of it did not. It went into the hands of the British Crown and the colonial government. So by the time of the later treaties, they were cash deals or money was involved. The earlier treaties, not so much, it was trade goods.
Kim, practically speaking, what does it mean that the Mississaugas didn't cede the water?
Well, that will be a very interesting thing to find out. we have asserted in the claim that we filed with Canada and Ontario that they still own the water and they still own the land underneath the water. That would have tremendous impact on the what the Mississaugas would call the settler governments. Everything from the Sir Adam Beck generating station at Niagara Falls, which has been generating millions of dollars worth of electricity from the Mississaugas water since 1921, 100 years now. I used to work for Ontario Hydro, so I know about that pretty well. But and think of the city of Toronto. Front Street is called Front Street because back in the day, it was the front. I mean, when you stood on Front Street and you looked the other side, what you saw was Lake Ontario. So everything south of Front Street is built on landfill.
Right.
Land that the Mississaugas assert that they still have title to. So the water claim would have massive impacts on both Canada and Ontario if and when we find out there. But as I say, it's a big case. There hasn't been a lot of court decisions in Canada on dealing with Aboriginal title to water, and the Saugeen and Ojibwe Nation, which are up past Midland on the Bruce Peninsula, they're in trial right now in the Ontario Superior Court, alleging that they have Aboriginal title to water in their territory. So we want to see what happens there, and then we'll move it forward from there. But yes, if the water claim were accepted at face value, it would have massive impacts.
Kim, in your settlements, do you, this is Susan speaking, do you have visibility when there is a settlement and there is a payout by the Crown as to where the money goes? The reason I'm asking, I wasn't involved, but I am familiar with one case in another province, maybe 30 years ago, where there was a huge payout to the Indian bands for a land settlement. And I mean, I'm talking hundreds and hundreds of millions of dollars in today's dollars. That money was seen by very few and basically evaporated, and the bands that were to be benefited from that did not see the light of day. So I'm just curious, when there are these big settlements, what is the process in place that it's for the good of the whole and maybe less scrupulous groups?
Yeah. What I do with my clients, generally speaking, if it's a large claim, we set up a trust agreement so that the First Nation establishes a trust, often administered by Peace Hills Trust, which is a First Nation owned and operated trust company out of Alberta, owned by Samson Cree First Nation. They have $1.5 billion of First Nation land claim settlements in trust that they administer for the First Nations. And we write out a full trust agreement that's binding on the First Nation. It documents all of the money. So all of the money that's paid to the First Nation is set out in the trust agreement. It then sets out the rules for how the money is to be invested and spent. And you can track it. You know exactly, if they make $1 and they spend $1, you know what they spent it on. It can't go into the hands of the chief. It can't go into the pockets of the councillors. There's complete and utter transparency. They have regular meetings with the members where the trustees come and say, okay, with the Toronto Purchase Trust that we established when we settled the claim in 2010 with them, they got $145 million for that. They have 120 million in the trust today that's generating between $5 and $7 million a year for them in income, and every penny of that money can be traced and shows exactly where it goes to. Any member can get an audited financial statement of the trust. So we set up very transparent and these are trust agreements that the members themselves, the members of the First Nation, have to vote on. In order to settle a land claim, they have to vote on the settlement agreement itself with Canada and on the trust agreement to say, yes, this is how we want to see the money paid and invested. And it works very well. So First Nations that have set up trust agreements, and I've done about 15 or more of those now with various clients. The trusts, many, many years later, and these are trusts that will last for 100 years and will benefit the nation for 100 years. So it's not just the members today that get a benefit, it's their children, their grandchildren. It's the concept of 7 generations. These trusts will benefit 7 generations of Mississaugas of the Credit. And they have every intention with Treaty 22, when and if they settle a claim, they would establish a trust to deal with those funds. So that was a very good question, and not all First Nations are that good, but Mississaugas of the Credit and most of my clients are that good. They're wise with their money. They're good Protestants.
Thank
Kim,
you.
I've got a question about the beneficial use of both the land and the water. So in the claims, are they just looking for financial compensation, or are they also looking for the ability to use that land, whether it's for hunting and whether it's for using water? Because I think water, well, that's what I happen to be into. So, water is extremely important globally right now. And when you're talking about water, you're talking about Great Lakes, you're talking about the US, it's an international sort of issue. So are they looking in any of these settlements to also have more of a use into perpetuity sort of arrangement?
Yes, very much so. And they're very interested in protecting the water. They're very interested in exercising what they see as their duty to be a steward of the lands and the waters. When we were first working on the water claim, we established a water committee that met with many, many different First Nations members, and we had lots of community meetings and got input. And they didn't want to just surrender their water and take some cash and walk away. They said, we have a duty to this water. We have a duty to this land. We want to see it protected. We want to make sure that 7 generations from now, we still have clean water that we can drink. We still have wetlands that will, provide for the ducks and the wildlife and the amphibians and the fish and the things that crawl and the things that fly. So they have a very, very strong interest in, it's not just money that they're seeking. They're seeking ways of protecting the land, protecting the water. But Canada and Ontario tend to sort of steer them, well, Canada in particular tends to steer them towards money, take money and go away and don't bother us. And Ontario, in a claim in Northern Ontario, it's not a problem finding land to settle a claim, generally speaking. There's lots of unoccupied Crown land north of Lake Superior. I worked for Treaty 9 up in Mississauga, up in James Bay and Hudson Bay, and I worked for a lot of Robinson Superior First Nations. When we settle a claim up there, we don't have trouble finding land to set aside as reserve for them. There's millions of acres of Crown land that we can look at. Oakville, not so much. But we've talked to Mississauga, and we talked to them about maybe Arundel Park. They'd like a presence on the Credit River. That was their preferred location and their heartland. We've had some discussions with Mayor Bonnie Crombie and others about perhaps trying to establish some sort of presence on the River Credit. So we're hoping that the settlements for these claims will not just be money, but also would be some land and perhaps some stewardship of waters as well. I hope that answers the question as best we can.
Yeah, that's great. Thank you.
Actually, maybe it would be a good thing if they looked after the water to prevent all these bottling companies from taking it. So
yeah,
we've had discussions with Nestle's, and we're not too pleased with them. So
I'm sure.
But I understand that there are some rules where First Nations actually do have access to water. They can actually sell water as long as it's in the size of, say, a bottle or whatever, that they are allowed to do that. And I don't know, again, I don't know how the law works on that, but they have different rights, I think, to to non-Indigenous people or non-First Nations people. Is that true?
On an Indian reserve that was recognized, set apart as a reserve, generally it's looked as though they own all the water on the reserve. Different story if a river passes through, that's still covered by the Navigable Waters Act. But if you have a lake on a reserve, for example, or a spring on a reserve, I would think that you would be able to bottle that water. They could bottle that water and sell it if they wanted to. Probably require some sort of permit from Ottawa under the Indian Act, but they could do it that way. But off reserve, at Canadian law, they have the same rights with respect to water as everyone else, unless we get that changed.
I'll talk to you about that.
Okay, please.
Kim, I think you said that generally speaking, the Mississaugas didn't have it originally a concept of owning land. And they basically ended up taking over the territory through battles and wars and driving other First Nations people out. So I'm assuming that they didn't compensate previous First Nations people that were here. They just through battles drove them out, right?
Yeah.
And yet the expectation of what you're working on now is that even though, I mean, we didn't drive the Mississaugas out because they're still here, thank goodness, but we obviously reduced them in size and location. So why is that concept different?
They don't, I mean, in English jurisprudence, I mean, we have the concept of fee simple ownership of land, where you own a piece of property, an individual owns a piece of property, you can buy it and sell it. I mean, the First Nations did have a concept of whose land was whose, and they knew that very well. So this was Mississauga territory. Upstate New York was Mohawk territory. Georgian, up by Georgian Bay was the Chippewas. Down by Walpole, you had the Three Fires Confederacy. Down by by Windsor, that was all Chippewa land. So they understood who had the right to use which parcels of land, but in any sort of Western concept of land ownership, not so much. And basically the original communists, they held everything in common. They, when they hunted and fished, they shared, made sure everyone was fed, and they didn't have a lot of possessions. And what they did have, they shared for the benefit of the group. So when the British came, or actually when the North Americans came, or not the North Americans, the settlers, originally it was quite a beneficial relationship for both. The First Nations got to trade they didn't have knives, they didn't have guns, they didn't have metal pots, so all these things were good. And there was very much a concept of that we would share the land, that you could come, you could build a fort, and we would trade goods with you. That's fine. A couple of settlers, okay, not a big deal. But when thousands and thousands and thousands, and we have records of the Mississauga saying to the British, I mean, you told us this was going to be a great deal for us. And now when we try to go and camp, the settlers shoot our dogs, break up our boats, they catch our fish, they drive us off our land. Like, what's going on? You said this was going to be paradise on earth. We were all going to live together and be happy. And these guys are taking over the joint, and they're not leaving much for us. So they were really quite surprised, shocked and appalled, I would think, they had no concept of the sheer number of Europeans that were headed their way. So these treaties were, okay, so there'll be a few British here, and you'll do your thing, we'll do ours, and that's the original concept of of the two-row wampum belt, was actually done by the Iroquois and the Dutch in New York. It was the idea that there were two canoes, each had their own canoe, and neither would try to steer the other's canoe. So it was like, the settlers had their canoe, the Iroquois had their canoe, and you'd live side by each, and everybody get along. And the Iroquois would rule themselves, and the Dutch would rule themselves, and that was that. And that was the way things started. Didn't last that way, and they were basically just overwhelmed by disease and the sheer numbers. And especially following the War of 1812. I mean, they were important military allies in the War of 1812. But once the War of 1812 was over and the North American borders seemed to settle down, the British lost interest in the Indians as military allies. And basically, they became the Indian problem, and they wanted to figure out how to make the Indian problem go away. So when they sold their land to the British Crown, I think all they were really saying is, yeah, some white guys can come here and live on our land. That's not a big deal. I don't think they had any concept that they were going to be overwhelmed and overrun.
Makes sense. Any more questions? Okay, then I would really like to say thank you, Kim. That was awesome and very educational.
Great.
Well, thank you very much. And this is my life's passion. This is my work, but I love what I do. And even my wife is a land claims researcher. That's how we met. And it was a bizarre story, but I started out, my father's home was on Staybank Road on beside the Credit River. And it wasn't until I started to work for the Mississaugas of the Credit that I realized that my father's home was smack dab in the middle of 200 acres that had never been surrendered. I actually grew up in an Indian reserve and didn't know it. So, and most of my places that I've lived have been on another Mississauga reserve, one way or another. I lived in Lorne Park, right off Indian Road. That was Treaty 22 lands. And here I am back on Treaty 22 here in Oakville. So I'm very, worked with them for 25 years, and we hope to get some of these claims done when I'm still able, and they're going well. And I'm very pleased that there's this much interest in what's going on, and we're very happy to communicate. And Chief LaForme is a wonderful gentleman, and we've done a great lot of work with the town of Oakville. They permanently fly the flag of the Mississaugas of the Credit at Town Hall. So they have the Canadian flag, the Ontario flag, and the flag of the Mississaugas of the Credit. So the mayor and the council here have regular meetings with the Mississaugas, good relationships, and a lot of good things are happening. So the Supreme Court of Canada keeps talking about reconciliation, basically saying, the settlers aren't going home. We've got to learn how to live together, and reconciliation is the way to go, and that's what's happening. And the Mississaugas of the Credit are doing very well. Thank you. So,
good.
And thanks again for the opportunity. Much appreciated.
For more information about Oakville's history, visit our website at oakvillehistory.org, our Instagram page at Old Oakville, or our Facebook page at Oakville Historical Society.